Good morning, students. Once again, welcome you to the business laws world. So, before we proceed with today's session, it is noteworthy that we should have the proper knowledge of basic concepts of law. So, as we have already discussed in previous lectures, that what is the business law and what is the study about the business law, or what are the contents of business law as we are going to study. So already I have discussed in previous lecture about the Contract Act as we are going through. So what is the contract? As I told you earlier, that contract is an agreement which is enforceable by law. So all the agreements we are talking about are enforceable if or every contract is enforceable if there are some essentials of valid contract. So today's session will focus on the capacity to parties. So today we are going to start this particular essential of contract, that is capacity of parties. But before that, we should have the small revision of the essential of valid contract. As I told you that if you are going to enter into a particular contract, you should keep in your mind that there are some essentials, that there should be an offer and acceptance, there should be a proper consideration, lawful consideration, there should be free consent, right? And some other essentials are that there should be a capacity of parties. Today we would be discussing about it, and it is very important that capacity of parties is what. So we have to know, we have to focus on this particular concept, because if the parties who are agreed to enter into a contract, or who are making the agreement but they are not competent to the contract, so there would be no sense of valid contract if the parties are not competent to any contract, to any agreement. So today we are discussing about the capacities of parties. This is an essential ingredient of any contract. It means the parties, we are talking about the offeree and the offerer, or the different parties who are the part of any contract, must be competent to a particular contract. As this is an essential ingredient of a valid contract, is that contracting parties must be competent to contract as per section 10, and every person is competent to the contract if the party is of the sound mind, is of the majority age, and is not disqualified from contracting by any law which the party is subject to. So there are three main points you have to keep in your mind. That the very first is the case of minor. It means the parties who are agreed with a particular contract, or who are entering into a contract. So we have to consider the age of the parties. The parties should be of age of majority, right? It means, what is the majority in India? As usual, the 18 years old is the age of the mature person, or the majority. And the person who is below the underage, it means the below 18, that person would be considered as the minor. So every person is competent who is having, or who is attained the age of majority. It means 18 or above 18. But if in the case of below 18 age, there is a case of the minor, so we have to be very focused when we are entering into a contract with some people who are the who are of age under below, right, particular 18. Every person is competent. The very first factor is age factor, and second one is sound mind. So what is the sound mind and what is the unsound mind, and what are the stages where we can enter into any contract with such kind of the people, we would be discussing about in the next slide. But before that, we have to focus on the capacity of parties. So, what is the competency of the parties to enter into a contract? We have to focus on it, because this is the particular topic for the today's session. So, competent person is that person, or the competent parties to a contract is that party which is of majority age, which is of sound mind, and which is not disqualified. It means if the person or the party is disqualified from contracting by any law to which they are subject to. So, in order to make any contract valid, we need to have this particular ingredient in our contract. This is the essential of the valid contract, capacities of the parties, right? Age of majority. So, what is that? Section 11 of the Act states that every person is competent to contract if they are of the age of majority according to the law to which they are subject. And in India, the age of majority is, as usual, is 18 years old, generally 18 years old, right? And minors, those below the age of the majority, if you are talking about the 17 years old boy, if you are contracting with, so that time you have to consider what is the age of this person, what is the age of the party. If the party is of majority age, you are allowed, you are permitted to enter into a contract with that party. Otherwise, if there is a particular case of minor, so there are few points you have to keep in your mind, or you have to consider while making the contract with that person, right? We would be discussing about in the next slide, but here is the age of majority you have to focus when you are entering into a particular contract with someone. So, capacity of parties describes that a person, a party you are entering into a contract with should be of the age of majority, and in India the general age of majority is 18 years. So, below 18, if you are trying to enter into any agreement or into any contract, so that time you should focus that there are few points we have to consider while making the contract. And when you are entering into the minors agreement, so these are the points you have to focus when you are making any agreement, any contract with the minor people, that an agreement by minor is absolutely void. Absolutely void. Ab initio, it means from the very beginning when you started to enter into a contract or writing the agreement for contract. So, an agreement by minor is absolutely void and inoperative as against him. Yes, this is the point. When you are trying to enter into a contract with the minor person, you should focus that the minor person's interest is protected by the law. The court is taking care of the interest of the minor people. It means they are safeguarding the interest of the minor people. So, it is very, very important that nothing can be operative against the minor people if you are contracting with the minor people. For an example, there is a case of the mortgage. Suppose any party is entering into a contract of the mortgage and the minor person has received the particular amount under a mortgage contract, for example of rupees suppose 40,000, and the minor person has received rupees 20,000, right? So, the other party cannot sue against the minor person to receive the amount back. Why? Because there is an agreement by the minor for only the benefit, and if there is a case of the minor and the party, the minor person is not paying you the back your money under any contract, for example the mortgage, so you cannot sue against that minor person because the court is safeguarding the interest of the minor people. No restitution, it means no compensation for benefit. It means there is no case of the recovery. If any minor has obtained or has gained something under any contract, so there is no situation then the contract can be enforced. No contract can be enforced against the minor people for the restitution. So there is a particular situation that there is no restitution, there is no restorage of the benefit which has been obtained by the minor person. So no party can force the minor person for the compensation for any benefit that has been obtained by the minor person. And the next one is the beneficial agreement or the valid contract. Very right. Because yes, there is a case. You can enter into a contract with minor only for the benefits. Sometimes there is a case of the partnership. In the case of the partnership, you cannot make the minor person as a partner in your firm, but if any minor you are taking into your partnership firm for the benefit purpose, it means the minor person would be beneficiary over there and would take the share of the profit, would take the share in the assets. But if there is a loss, if there is any adverse situation, the minor people cannot be enforced, cannot be forced to share the loss. So only for the benefits or for beneficiary, we are talking about the benefits of the minor people, only the person who are the minor can be made partners in a firm for the benefits agreements, for the beneficial agreements, and minor can be a beneficiary, for example, a payee and endorsee, right? And the next one is the no ratification on attaining the age of majority. Sometimes what happens, suppose anyone has entered into any contract with minor party, but if that party thinks that right now the age of the minor, right, as is below 18, and we should go to enter into a particular contract with that party, and after some time what would happen that after attaining the age of the majority, we can get whatever we can have the benefit from that minor, or we can go for obtaining the profits out of that contract. So this is to clear that if right now at present you have entered into a contract with a minor party, and after attaining the age of majority, if you think that you can recover or you can make that contract enforceable by law for gaining something else, so you are not allowed, you are not permitted by the law, because there is a particular concept of no ratification on attaining the age of majority. For example, suppose any party has entered into a contract with minor party, right, for selling a particular property, and you have registered your property, and you have made the particular payment to the minor person, and on attaining the age of the majority, the minor is not paying you the particular consideration. So that time, if you want that now this time this is the age of majority, and you ask to minor to compensate or to pay the consideration under the particular contract you entered into, so you cannot, because there is no ratification, there is no ratification on attaining the age of majority. What is the ratification? You have to clear this particular meaning, that the subsequent, right, it means subsequent, you cannot go for taking the response from that party, right. Minor's liability for necessaries. Yes, there is another agreement we have to focus on, that if there is a minor and any person who is supplying goods for the necessary or for surviving of the life of the minor person, right, and that person is willing to have consideration or to be reimbursed over there. So if the minor's liability is there, but in the case, yes, if the supplies are made for the necessaries for surviving of the life or for a particular purpose, so that time the minor, if the minor is having some assets, so out of those assets, the particular compensation or the amount of the supplies can be reimbursed, right. So that is the case of the minor's liability for necessaries and this particular concept is governed by section 68 of the Contract Act 1872. So I think now you are clear that exact what is the minors agreement, because different kind of the minors agreement you can enter into, and we have to focus when you are making any contract with minor. So what kind of the agreement you are going into, because no case should be there that is against the minor, only for the benefit of the minor. We have to keep in the mind that only for the benefits of the minor we can make any contract, we can enter into any agreement with the minor, because the court or the law is safeguarding the interest of the minor, and if anything goes against of the interest of minor, that would not be okay. So for example, mortgage, as I told you, and no restitution, just to revise, no restitution, no compensation for the benefit. You cannot restore, or you are not in the position of restoring the benefits which has been taken by the minor person, because there is a particular condition that no restitution, right, for any kind of the benefit. Yes. So there is a question that can any minor be partner in a partnership? Yes, minor can be a partner in a partnership firm for the beneficial agreements. As I told you that for the profits, you can make any person, any minor, a partner in a firm, but for loss, if you talk about, the person who is the minor will not share any kind of the loss. No ratification. If you think that after attaining the age of majority, the minor person would be liable, or would having the responsibility to make the compensation or the consideration under the particular contract you have you already entered into. So there is a case of no ratification on the attaining the age of majority. Few points may be considered while you are entering into a contract with the minor party. Minor partner, a minor can be admitted to the benefits of partnership, no doubt, as I told you earlier, and minor agent. Okay, he shall bind the principal by his act. So if there is a case of agency, there is a minor person, and who has entered into the contract of the agency. So if a particular act is done on behalf of the principal, that act which is done by, or which is carried out by the minor party, will bind the principal, or will make the principal of that agency, right, the responsible for any obligation. It means if any obligation arises out of any contract, that contract which has been entered into by the minor on behalf of the principal of the agency. So we have to keep in our mind that if you are entering into a contract with minor person who is part of any agency, who is the agent of any principal, so that time we have to focus that if any act is done by the minor, the principal would be bound by the act of the minor person. The next point is minor and insolvency. A minor cannot be adjudicated an insolvent. It means if there is a case of the insolvency of minor, the minor person would not be responsible for paying the debt, for making any compensation out of his personal assets under the insolvency. And surety for a minor, right? Another very important point, if any minor on behalf of the minor person, if any adult is taking the guarantee to repay the debt, so that time what would be the condition? There would be the condition of the contract of guarantee by an adult. It means the adult is taking the guarantee or surety for any minor person, that on behalf of the minor, I take this particular responsibility to repay the debt to anyone. So the law says or describes that if there is a case of the minor, so when the minor is not responsible, the contract of minor is not valid ab initio, it means from very beginning. So that time what is the question of making any adult person who is taking the guarantee responsible for that particular act. So we have to focus on the surety for a minor. And what about the position of minor's parents? No doubt the parents of a minor are not liable for agreement made by a minor, right, and minor shareholder. In the case of a company, if the minor person is going to hold the shares or is willing to buy the shares in a particular company, so there is a question. So we are talking about the minor shareholder. It means we have to think when there is a case of buying the shares or holding the shares in a particular company. So what is the condition of the minor? Can the minor have the shares in a company, or the company is ready to transfer or for transmission of the shares? There is a particular condition as per the company law that the shares should be fully paid up. If there is a case of the fully paid up shares, the shares can be transferred to minor or on behalf of the guardian. As per the law, the guardian can hold the shares in the favor of the minor shareholder. And the second position is the persons of the unsound mind. As we are talking about the capacity of parties, right? So the very first point, as I told you earlier in the beginning of this session, that we have to focus on three elements. The first is the age. What is the age of party? Because the contract will base, the validity of the contract will base on the age of the person. If the parties are having the age of majority, no doubt the parties can enter into a contract and the contract will take the validity, and there would be a case of the valid contract. But if there is a case of minor person, so different conditions we have already studied earlier. And the second thing is that the person or the parties should be of sound mind. If there is a case of the unsound mind, I would clear you that exactly what is the meaning of unsound mind and what is the meaning of sound mind, right? So what is sound mind? Section 12 of Contract Act defines the term sound mind as follows. So we have to keep in our mind that a person is said to be sound mind for the purpose of making a contract if that person is capable of understanding the sense, the consequences of the contract in which he is entering into, and forming a rational judgment as to its effect upon his interest, that to which extent the interest of that party would be affected by entering into a contract with someone. So if the party or the person who is entering into a contract is capable of understanding the particular effect of that contract, right, against his interest or in favor of his interest, if he is very well known or he is capable of understanding the meaning of the contract, the effects of the contract, right, and the extent to which his or her interest would be affected by entering into that contract, so we can say that the person or the party is of sound mind. But if there is the adverse situation, unsoundness of the mind are from the following, right? If any person who is of unsound mind, so how will you identify that this particular person is of unsound mind and we should not enter into a contract with that party? And for this purpose we can identify a person whether that party is or the person is capable of understanding the facts of the contract or is having the capacity to enter into that contract. So we have to identify that that is the case of idiocy or lunacy or insanity, drunkenness and hypnotism and mental decay. So one by one we just have a look on these elements because if any contract lies under these conditions, so we can say that the person or the party is not capable to enter into a contract due to the unsound mind. And what is the idiocy? As per incapacity of a person, right? This is the incapacity of the person, or you can say because there are some mental faculties, and if the mental faculties are disturbed or are not proper, right? So we can say that is the case of idiocy. And what about the lunacy or insanity? We can see that there is a case where the person is having the incapacity of mind due to any reason, and he cannot understand the particular meaning. He is not having the proper senses of a sound mind and proper faculties of the sound mind. So there is a case of the lunacy or insanity. But there is a particular case of lunacy, right? So you cannot go in to enter into a particular contract. And what about the drunkenness? Again, the temporary incapacity under the effect of intoxication, or if you are having some substances which are affecting your mental ability to understand the effects of the contract. So there is a case of the drunkenness which is making a party or the party to the contract incapable of understanding the meaning or the effect or the consequences of any contract. Hypnotism, again, under the impact of artificially induced sleep, there is again a particular case where we should think while we are entering into a contract. If there is a case of the hypnotism, or the person is under the impact of artificially induced sleep, so we should not make the contract with that party. And mental decay on account of old age, we can see, if the person cannot memorize or cannot understand or lose something of the mental ability, that is the case of the mental decay. So if the person is of unsound mind, we should not enter into a contract with, because there would be no sense of valid contract. It is the essential ingredient of any valid contract that the parties with whom we are going to enter into a contract should be of sound mind. If there is a particular case where the parties are not of sound mind, the particular contract or the agreement cannot be enforced by the law. So, in order to make any contract enforced by the law, we should determine that the person or the parties we are entering into a contract with should be of the sound mind. And if there is a case of the unsoundness of mind due to any reason, we can say there would be no valid contract. So, persons of unsound mind under the capacity of parties, this is the very important second point. And third one is the disqualified person. The very sometimes the people may get confusion that what about the alien enemies, what about the foreign sovereigns and ambassadors, and what is the sense of convict here, and what we are discussing about the married woman's property or the contract with the married woman and joint stock company. So one by one we would be having the look over here. The alien enemies. What do you mean by the alien? The very first question comes to your mind that what about the aliens? So alien are the citizens of the foreign countries who are living in India, and those persons are coming into a particular contract. So we have to focus that if there is a case of declaration of war between the countries, right? Suppose two countries are there. The first is India and the second another country. And in that case, if the particular person or the citizen who is belonging to another foreign country, and there is a case of the war declaration, so we should not enter into the contract with that person, because there would be the case of the alien enemies. And if the war is over or there is no any war, so you can enter into a particular contract or you can go to revive the contracts, right? And foreign sovereigns and ambassadors, these are the person, these are the key people. You cannot enter into a particular contract, so you have to be very focused if you are entering into a particular contract with these kind of the people. And convict, so next person who is disqualified by the law, by the Act 1872 Contract Act, that if any person is imprisoned, right, or is guilty of any act and is imprisoned, so that time under the period of the imprisonment we cannot enter into a contract with that party, but after the particular sentence is over we can enter into a contract with that party. And married women, there is another case of married women, that if any woman is entering into a contract, so out of his her personal property she can enter into a contract. But there is another case when for the necessaries of his life, or she can sue on the husband and can take the benefit of her husband property. So there is a particular case that if you are entering into a contract with the married woman, you have to consider whether she is entering into contract out of her personal property or her husband property. And the next is the joint stock company. So we are talking about the companies, no doubt corporations. And if you are entering into a joint stock company, so as we know that there is a particular memorandum of association. This is the main document of the company which is to be submitted at the time of incorporation of the company and which guides the companies to act. So if there is a case of the joint stock company and you are entering into any contract, or if you are going to make any agreement with any joint stock company, so you have to focus on the memorandum of association of the company, because every act of the company would be bound by the memorandum of association. So these are the people, or these are the persons who have been disqualified for entering into a contract, and there would be the different cases. So we have to focus, or the students are advised to focus on these people, that once you have decided to enter into any contract with such kind of the people, there would be some conditions. So now I think that to be a valid contract, it is a essential ingredient that capacities of parties should be there. And once you have decided to enter into a contract with someone and the party is not having the capacity, and capacity in the terms of age, in the terms of the disqualification by the law, or as I told you that different conditions are there. So you have to focus on the age of the person, on the soundness of the mind, and the qualification or disqualification of the person you are going to enter into a contract with. And I think now this particular essential of the valid contract is good with you, and you are having the proper knowledge of this particular concept, because as I told you earlier that in order to make the study of the business laws, it is very important that we have to focus on the essentials of the valid contract, and one of them is that the particular capacities of parties. So if the parties are very competent, if the parties are competent to enter into a contract, it would be good for everyone to enter into a valid contract. So guys, I think this is the time for this to end this particular session, and in the next session we would be taking about the another essential of the valid contract. Thank you.